This is Michael Popok with a special Legal AF hot take of my interview with Judge J. Michael Luttig, a Federalist Society lion, director of the American Constitution Center, a Federalist at heart, constitutional scholar, and a patriot. He and I talk about the recent decision by the United States Supreme Court, in which, in a peculiar either 9-0 or 5-4 decision, depending upon how you count it, the United States Supreme Court ruled that the 14th Amendment, Section 3, doesn't say what we think it says, and has written it effectively out of the Constitution and disabled courts and federal courts, all the way up to the Supreme Court, from making decisions about who is an insurrectionist and who should not be. Listen to my interview. Here's a clip of that particular analysis, and I want you to hear from Judge Luttig, who's an important voice at the intersection of law, politics, and justice. Let's play it. We had you before. We were honored to have you before to talk about what you thought based on the briefing, the airtight analysis that came out of the Colorado Supreme Court in their decision to find both Donald Trump was an insurrectionist through a trial process. It wasn't just something they got up one morning and considered. And then having the oral argument, which went south quickly on what we thought was the proper analysis, with Judge Roberts, for instance, immediately, that's why you can see his hand all over, in my view, the hand all over the decision, where he said, well, every other part of the 14th Amendment and the Civil War amendments was about restraining state power. Why would we be empowering states to make a major decision about who can be the president of the United States in a federal office? I said, oh, here we go. Once he went down that road, although there wasn't a lot of discussion about Section 5, I thought our goose is cooked here. So I want to get your view of what happened with Anderson. What's your view of the decision by the majority, the 5 in the majority, the 9 for at least finding that Colorado, a state, cannot take a federal officer candidate off the ballot, and how the majority went even further than that and its implications? Then we'll turn it into the immunity discussion.
Well, Michael, the decision was remarkable, even astonishing in every single respect. This was arguably one of, if not the single most important constitutional and political case before the Supreme Court since Congress created the Supreme Court, I believe, in 1789. And of course, going into the argument, that's what all of America believed the case to be. The story of the decision really began the day of argument. There was a 2-hour argument back in February, on February 8th, I believe. And that was the most remarkable argument that I've ever heard in the Supreme Court of the United States, for this reason. In the entire 2 hours of argument, the court barely asked any question about any of the 5 momentous constitutional questions that it had to decide in order to decide the issue that was presented in the case, namely whether the former president is disqualified under the 14th Amendment from holding the presidency in 2024. It was so remarkable that the preponderance of the probative questions by the court were leading questions to the former president's lawyer, Jonathan Mitchell. And as I was listening to the argument, what I heard was that in every single instance in which a member of the court asked Mr. Mitchell a leading question, suggesting that the member's question proved that the former president was not either subject to disqualification or was not disqualified at all, Mr. Mitchell responded to the questioner by saying something to the effect that, well, actually, Your Honor, that's not correct. That the analysis that you just asked me about does not support my client. Or if it does, it only even up to the most striking question and exchange that I heard, where one or two of the justices asked Mr. Mitchell, "Well, I'm mystified why you're not addressing what I thought was your main argument in this court, which is that the president is not an officer of the United States for purposes of Section 3." And Mr. Mitchell answered that question in the following way: Your Honor, actually, that is not our main argument. And it's not our main argument because we understand that that's a difficult argument for my client to make. Now, so what was crystal clear to everyone in those 2 hours was that the Supreme Court never intended to decide the question presented to it. Not that day, not the day of decision a couple of days ago, not ever. So what did it do? It searched in vain, in my view, for a way to decide the case, dispose of the case, I should say, without ever deciding any of the major constitutional questions presented. And it seized upon the one that represented the per curiam opinion, though, very importantly, only the opinion of a majority of 5, not the remaining 4 justices who concurred in the per curiam, but concurred only in the result, not the reasoning or the thinking that was laid out in the per curiam opinion. Again, all of this is absolutely extraordinary, Michael, for what was to be a landmark decision by the Supreme Court of the United States. Again, in quick summary, a very short per curiam opinion. There was no named author of this opinion. Per curiam opinion, that the result of which commanded 9 votes, but the reasoning of which commanded only 5 votes. And then, perhaps the most extraordinary aspect of this per curiam opinion is that the 5 justices, majority of the court, in the per curiam opinion for the 9, went ahead and decided a handful of momentous constitutional questions that were not even presented by the case and that were not necessary of decision given their narrow holding. And it decided that handful of momentous constitutional questions in such a way that not only is it clear that the former president will never be disqualified under Section 3 of the 14th Amendment, no person in the future who engages in an insurrection or rebellion against the Constitution of the United States will be disqualified under Section 3 of the 14th Amendment. That, in effect, the Supreme Court, a majority of the Supreme Court, annulled or nullified Section 3 of the 14th Amendment. And Section 3 of the 14th Amendment is the Constitution's safety net for America's democracy.
Yeah, I want to talk through that with you now. And I agree completely with that analysis, because the other provisions of the 14th Amendment that, and I'll just call it out, I think Justice Roberts wrote most of this, or at least somebody aligned with him. The other provisions of the 14th Amendment, I get that Section 5 requiring Congress to pass enabling legislation or take other steps to ensure that the policy decisions and the law that's in the Constitution is abided by and is effectuated. I get that, and that's why you have, things about voting rights and things about disenfranchisement, because so that the newly freed, now Black Americans have the protection of the 14th Amendment through other legislation. I understand that. But I agree with you that the 14th Amendment, Section 3 on its face has always been self-affecting. You don't need any enabling. You don't need something in the code of federal regulation in order to disqualify someone. What they latched onto in the opinion, I want to get your opinion on this. But one side note, just for full disclosure, Mitchell clerked for you at one time, didn't he?
He did, Michael.
Yeah, just want to be clear. Yeah. So if you know from whence you speak, they right from the beginning, the language that the Supreme Court chooses, of course, has great import. And right in the beginning, I knew we were in trouble on the first page when they said that the respondents, these voters whom we refer to as the respondents, contend that after former President Trump's defeat, he disrupted the peaceful transfer of power by intentionally organizing and inciting a crowd. That's not what happened. A court of competent jurisdiction, after hearing evidence, determined that he participated in an insurrection. They just don't like that as the tribunal or the power to do it. And here's the inconsistency. I want to see what you thought about it. I don't know how they could possibly hold these two competing ideas in their minds at the same time. How could it be okay, as they say in the opinion, for a state to disqualify a state office holder or candidate who participated in insurrection from their ballot, but not a federal one because of Section 5's requirement, in their view, that there be additional congressional legislation? Well, what happened to the state doesn't require it, the additional congressional legislation? And what is the additional congressional legislation? Are we now, the new Congress, going to have to set up tribunals? Are they going to have to set up congressional courts? Are they going to now have to delegate to the Department of Justice and the federal courts the power to try this? What is the next thing? Because we got to know for the next Congress to know how to now write back in to the Constitution the safety net that you said, that, which I agree with, they just wrote out.
Michael, there were compounding errors beginning with the first paragraph that you just recited. And we, first off, it's just transparent to anyone that studied the Constitution that every step of the analysis, even on the result that garnered the 9, was fundamentally wrong. But to address your questions first, Section 5 is permissive. It doesn't say that Congress shall legislate appropriately to enforce Section 14. Amendment 14th Amendment. It says Congress may. That is constitutional language that says Congress need not legislate in order for the right or the privilege, or in this case, the disqualification, to be self-executing. And we have many examples throughout the Constitution, not just the 14th Amendment itself as to Section 1, but the 15th Amendment and other places in the Constitution where that language has been read as it's written to make congressional legislation permissive but not necessary. And then you cascade down to the holding under the 14th Amendment as you've described it, namely that the court held that Section 3 was intended as a limitation on the states, and a limitation that prevented them from disqualifying from their ballots, the primary ballots, and presumably also the general ballot, Michael, though I'm not certain of that. And on the reasoning that, as Chief Justice Roberts said, well, obviously the 14th Amendment was ratified as a restriction on the states. My answer to the Chief Justice and to the court is, yes, indeed, it was. It restricted the states from offering for federal office insurrectionists against the Constitution of the United States. So, in other words, the Supreme Court turned the 14th Amendment on its head and against the Section 3 facial and textual allocation to the states of the power to disqualify under the 14th Amendment, not just state officials, but federal officials as well.
That is so perfectly put, Judge, and I haven't heard anybody else, even in your other interviews, talk about that. Why would we ever want to prevent an entity, state or federal, from removing insurrectionists from government? Isn't that the purpose of the 14th Amendment, Section 3, no matter who does it?
Yes, of course it is. And it's axiomatic that
Well, that's an example of what we do on a show we call Legal AF on the MeidasTouch Network. We have a main podcast every Wednesday and Saturday at 8 p.m. Eastern Time on this network. And then we do interviews like that with leading figures and newsmakers and legal experts from all across the political spectrum. We bring it to our audience just the way we did right there. So I invite you to join us on Legal AF, again, right here on the MeidasTouch Network and on audio podcast platforms of your choice. And the leaders of Legal AF, like me, Michael Popok, we do hot takes like this one about every hour at that intersection of law, politics, and justice. And we do it right here on the MeidasTouch Network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.